I have a live stream up, and Karen is crying and is hugging.
Welcome to an impromptu sit down with attorney Luke Hisadia, a South Jersey criminal defense attorney, investigator, former sheriff's deputy, current police officer, former homicide investigator, Chris Lyons, who's been on the show a couple times to talk about DNA. And we're having a chat about the Karen Reed verdict. We're going to jump right in.
And where were you law enforcement, Chris? Remind me.
Florida, Tampa
Florida.
Bay area. Just like everything else in this case is completely confusing. I don't know how you can ask a yes or no question and have it be so complicated. It doesn't matter what you know in a case. It matters what is admissible under the rules of evidence and, our Constitution and what you can prove. And in this case, I really felt like they didn't. And then there was a lot of things. And also, as a defense attorney, you're allowed to basically explore any reasonable cause for defense, and there was just constant rulings about how like they couldn't mention the property where he was discovered and the occupants of those properties and those different things, which is absolutely ridiculous, because if you were found dead or dying on somebody's lawn in a residential neighborhood, wouldn't speaking to that person that owns that house be important?
Yeah, I mean, well, let's do this, Chris. I want to back up real quick. So just real quick, we're here for the New Jersey Criminal Podcast. We're here with Mr. Chris Lyons. He's a former law enforcement down from Florida in the Tampa Bay area. We're going to be talking about the Karen Reed case, and coincidentally, we're doing this the same day that they came back with the verdict. We just listened to it. It looks like it was not guilty across the board. Chris, I'm going to ask you some real basic questions about the case, and we'll get into all the details and all the specifics. I don't really know very much about it. Obviously, I have, my history as a prosecutor, and, I'll comment and answer any questions maybe you have about, my thoughts on different things. But let's start here. Let's act. I want to treat this video for like it's being watched by somebody who has not followed this case at all, and is wants to kind of get all of the ins and outs of it as boiled down to fine point as much as possible, in one video. So why don't we do this? Tell me from the beginning, like, who is Karen Reed? What is she accused of? Where did it happen? And what
Yeah, so
exactly
Karen
are the
Karen
accusations?
Reed is a lady that lives in Canton, Massachusetts, which is a suburb of Boston. She was dating a man who was named John O'Keefe, who was a Boston police officer, and they had many friends that lived in their community that were in different levels of local and state and federal law enforcement. So, in 22, yeah, January 28th, and a group of friends had gone out for some kind of, I don't know if it was a celebration or just like a get together, and they had gone to several local places in the Canton area, had some food, had some drinks, and then we're gonna take the party to a private residence within Canton and continue the fun there. At some point, the prosecution alleged that Karen Reed had dropped off her boyfriend John O'Keefe at the residence of Brian Albert, and while intoxicated, either intentionally or unintentionally struck him with her car and then left the scene. So that is the basic premise of the case. So she was tried in 24 in the same court in the same jurisdiction, and they brought the same three charges. They came to a not guilty on two of the three, and then on one they were hung. And the judge declared a mistrial on all the charges, which I thought was improper. I'm not a judge, but
Yeah, I mean, I can only speak to New Jersey law. I don't know what's going on over in Massachusetts, but partial verdicts are very common. I mean, even from a lesser included offense to the formal indicted offense, you could have a not guilty on the. I mean, I had a homicide where there was a lesser included offense of aggravated manslaughter. They found him not guilty of the murder, and they hung on the aggravated manslaughter. And then we retried the case later on the lesser included. So yeah, it's very odd to me to hear that the judge wouldn't take a partial verdict.
So I've seen in trials in my experience where initially if the judge has some kind of conflict, they will state that before a jury selected in Florida, what we call during a pretrial hearing, and the judge will say something like, I previously oversaw a case in which, this client was found guilty or not guilty of X, or I have a pending case that's unrelated to this with a co-defendant of the person in this case. Get it on the record and basically ask both the state and the defense and the defendant, hey, this is the situation. I want you to know this going in. Do you have any issues with this matter that you feel it would affect my ability to be fair and impartial during this case? And if you have those types, I think getting it out of the way up front, it just shows a lot better, like a level of integrity, and also that you're just laying it out there and you're saying, this is what the situation is. I want you to know about it, because every judge wants to avoid issues.
Yeah, I mean, there's a lot of deference given on conflict issues as to whether the court needs to recuse themselves. They should consider it's not just about whether they actually have a conflict, it's about whether there's an appearance of a conflict. And New Jersey really harps on that a lot, I think a lot more maybe than Massachusetts does, but certainly, any trial, especially this one, getting all the notoriety and all the publicity, the appearance of impropriety is almost just as important as actual impropriety. So, there's definitely an argument to be made that she should have recused herself just to create a good appearance of fairness, like on a case that's being viewed by thousands of people on the news. I certainly could see an argument to be made there, but unfortunately, not a lot of cases get a lot of publicity. So there's, a mentality, I would say, I don't have a conflict there. Like, oh, even if I did, like, oh, I don't even know who this person. Yeah, maybe I rent to this person, but I don't know who this other person is. Like, I can sit on this case and not have any issues. And maybe that's true, but it doesn't look great. And unfortunately, these judges in a lot of courts, they're not used to the type of publicity you're getting out of this case. So, once they made the decision, maybe they look back and said, well, maybe we should have recused ourselves. But at that point, it's too late. You can't say, oh, I have no conflict, and then say you have a conflict. It looks even worse. Yeah, I can see that becoming an issue from a public perspective. And then I could see the thinking behind the bench in the chambers and, with court staff, all like, oh, I can't recuse myself here. Like, how many other judges have similar situations, or maybe not exactly the same, but other types of alleged conflicts? We would be recusing ourselves all the time. And then all of a sudden this becomes a media storm and, they're like, maybe we should have done it. But moving on from that point, because I want to cover, as much as we can about the case in the time that we have. Tell us more about the case, Chris. So, like, you left off there. It was tried. It was hung. They didn't reach they maybe reached a verdict on some of the counts, and they didn't reach a verdict on the other ones. But in either case, it was obviously retried on all the counts. And I'll just say, the fact that I would be very surprised. Surprises me very much that the defense didn't have something to say about the partial verdict. So it just seems to me, as just being involved in this process for 10 years, that there's maybe something more to it than simply that they had a verdict and they didn't let them reach a partial verdict. Jurors are not allowed, generally speaking, to become witnesses. So there's a lot of, at least in New Jersey, there's a lot of court rules that prevent you from really questioning a verdict by calling a juror to the stand to talk about what went on in the jury room, because the court system protects.
You can't discuss the deliberations, but I think what would have been effective remedy is to poll the jury.
Yeah, they should. I mean, that should have been on the record. If that wasn't on the record, that's a blatant problem.
It was not.
But I guess what makes me scratch my head is if that did happen, the defense attorney should have been all over that. I mean, he should have been making a huge stink over that. And for him to not do that makes me wonder, like, what are we missing?
So they did. They tried every point to be fought. I felt that they raised every issue they could. I felt where the problem was that they kept getting deflected was she would make a ruling and then essentially want to kick it to the appellate level and basically say, this isn't a trial issue, this is an appellate issue. So she would make a ruling on, item X and then want to move forward with it and basically say, well, you can take it up at the appellate level in the future. But to a defendant, when their life is on the line and they're being prosecuted, one, being found guilty of anything is crushing, but especially murder, and then to say, oh, you can take it up at the appellate level. I mean, those cases take years. And we have
Yeah,
Florida
sure.
cases that are homicides from the 80s and 90s that still have, usually trying to exonerate the defendant, but where they're still at the appellate level. I think down here it's the second DCA, trying to have things changed, suppressed, resentencing guidelines and everything. Very frustrating to watch it on the live feed is the amount of sidebars. I understand there's certain issues that can't not be argued in front of a jury. I understand that the judge in courtrooms, they don't want to have to excuse the jury every time there is an issue. But I read in some national publication, so they don't think I'm stealing it, but they use the term trial by sidebar, which I thought was a very interesting term, because the whole point of having a criminal trial is you have to lay all your cards on the table. There's no secrets. And everything that the state has to be clearly explained, identified, what the source of that material is, what their evidence is, statements, witnesses. There's no secrets. And to, in a courtroom, constantly have sidebars that are outside of the view of the public. And then, like I said, I can understand
Sidebars with the jury in the room or not in the room?
both.
Yeah, I mean, when the jury's in the room, that's very common. When they're not in the room, obviously
So this is
sidebar then is just to keep it secret from the public.
watching the trial, though, and we watched, both the first trial and the second trial, is basically when an issue, whatever the issue was becoming a heated topic, then all of a sudden they would go to sidebar. So I felt that it was unfairly utilized, in that, every time something might be discussed that you don't like, you can't utilize a sidebar to, shelter it. When I was younger in my career, I thought, well, the judge is a state employee, the judge is on the side of might and right, and the judge is here for law enforcement. But they're not. Much better analogy is to think that the judge is a referee in, like, a basketball game. They don't have a stake in who wins. They're the arbiter of the process to make sure that both sides play by the rules. They should not have a vested interest in the outcome of the case. If the defense presents a great case and they get a not guilty, then they did a better job than the state. If the state presents a great case and is very well put together and makes a compelling argument, and the state gets a guilty verdict, that's how it's supposed to go. I felt there was a lot of times, kind of like you said, Saved by the Bell, where the defense really had a good flow going, and then all of a sudden it was either done for the day, break, lunch. And this is just my interpretation of it. I don't have any inside knowledge, but I felt like there was opportunities where the defense team was really on a good roll about a particular issue or with a particular witness on the stand, and then she would break that flow, which ruins the rhythm, because the whole point is you're trying to get, towards something to, prove or disprove. And, I think, like we talked about on offline on the phone the other day, when this comes out like a fully written transcript, I'd be really interested to know the number of objections that were overruled or sustained by both sides. The objections must be probably 10 to 1.
They used to say that, the prosecution wants a guilty verdict, the defense wants a not guilty verdict, the judge just wants the case to be over. I have no doubt that the judge wanted to. I mean, you want to look back, you look at the O.J. Simpson trial, and they teach it in law school. And one of the big problems the court had in that case, and the mistakes that the judge made, is that he just didn't let things like get ruled on. Everything was dragged out to like the most extreme, and the case dragged on for like, what was it, a year? So, and then you have the other extreme, which is I want to just rule on this and move on. I don't want to like turn it into a mini trial on all these things. So I'm not going to give the time maybe that they should give on it, in a happy medium situation. So yeah, so I hear, I've definitely been there where a court's like, what, take that up on appeal. It's hard to sit here and tell you. I don't know what was said at sidebar, right? Like, did they let they cut the defense off? Did they say, I heard enough, I'm not going to hear anything else? I don't know, like no one knows. But let's talk more about the facts of the case. So obviously there was the mistrial. The body was found in front of this home. Tell me more about the facts, Chris, and the evidence that they had.
One of the most interesting things to me is I was contacted by somebody who's in law enforcement within the state of Massachusetts. You are allowed by their trial rules of procedure. You can mention a previous proceeding if it resulted in a mistrial. In
Right.
Florida, that is an absolute no-go. You will be looking at a mistrial and probably some kind of censure, immediately. So I thought that was very interesting. They danced around the mention of the FBI a lot, which I thought was completely ridiculous. I don't understand.
Just to clarify, you're saying that they could, in Massachusetts, they can say that there was a prior trial and it was a
They talked
mistrial.
about it all the time. So like the witnesses would stay on the stand, like
In New
because
Jersey, you have to it comes up obviously because there's transcript of prior testimony. It comes up all the time. You have to call it a prior proceeding.
that's what they
Can't
did.
say.
That's what
Is
they
that
did.
okay? Yeah, then
They
that's
called it a
in
prior
line
proceeding,
with
but
how New Jersey. Yeah, they said in a prior proceeding, did you testify to X, Y, and Z?
yeah.
Yeah, that's it. That's the rules in New Jersey too.
So with all my experience being here, there's things that are different. That was being one of them. My wife, who's also in law enforcement, we saw that where they had some witnesses on the stand and they were talking, like one of the witnesses, not trying to be obtuse or deceptive or anything, said something like, well, in the grand jury or at the first trial or something like that. And I mean, we looked at each other, we were completely shocked, like we were waiting for a mistrial, like a motion for a
Yeah,
mistrial immediately, and it didn't happen. And then that was when I found out that they were allowed to do that.
I mean, I suppose by agreement, you could, if both sides like put on the record and say, we don't have any objection to mentioning it, then it's, you could, but yeah, in New Jersey, it's pretty like, oh, sidebar, like in its potential mistrial or some sort of instruction from the court. You heard the testimony about it. Don't consider any of that. It doesn't matter. But yeah. But so what evidence did they have against Karen Reed that she was like so they find like his body, like when did they find the body? The next morning?
Around 6 in the morning on the 29th, they find him alive, but, in very poor condition on the front lawn of the Alberts.
And what are his injuries?
His injuries, primarily, he has like a basal skull fracture,
Okay.
and then he has highly, highly contested wounds on his left arm, on his right arm, that the state was asserting are from traffic, impact injuries, and the defense is asserting from dog bites.
Okay.
So he's transported to the hospital. I don't believe he ever becomes conscious again.
Right.
And, they do their best to try to treat and resuscitate him, but ultimately he dies of his injuries.
So she drops him off there, leaves, and he's supposed to come back that night later, and he never gets back to her. So she goes back there in the morning. Is that her version? I mean, is that you hit by a car and you're outside for 5 hours and you're actually still alive with those types of injuries?
So what's interesting about the snowplow driver is he remembered that specifically there was a vehicle parked in the street. And a lot of states, especially in the Northeast, especially during the winter, have a rule about no overnight parking in case of, that the roads need to be cleared. So he remembered that a vehicle being parked in the street, which was in the way, and basically had to go around it and then continue clearing. So that was why he was so specific about remembering
There's no body there.
that house. And then also he knew that a police officer lived there. It's a small town. This guy, he was like a public works type of employee.
What was the cause of death? Blunt force trauma, internal bleeding.
Basically the basal skull fracture, like the swelling of the brain. Not exposure though. That the state, or I'm sorry, the defense had a much better explanation of cold injuries this time. Something I wasn't aware of because, believe it or not, it doesn't get very cold here, where we have a lot of hypothermia deaths.
Cold in Florida?
No, it doesn't get cold. So when somebody is exposed to cold weather for a very long time where it starts to really affect their internal processes, you think about frostbite and your skin turning black and things like that. But this doctor testified that it actually does something very unique to the lining of your stomach with these ulcers. It's something that your body does. And he did not have that post-mortem. So that defeats the theory that he was outside for an extended period of time and died as a result of exposure to the cold.
And how did they, like, they obviously didn't have video or eyewitnesses to say that she hit him with the car. So how did they, like, develop that as a theory that she hit him? Like, where does that start? Well, I will say that possibly, but in my experience, those Ring doorbells, depending on the settings you have on them, if it's too far away, they don't get triggered on the motion, and they don't record anything. I've
Well,
had
what
cases for
what
that,
the
but
issue was with that, and I've
yeah,
encountered the same thing, is like if a person walks by on the lawn, it might set it off, or on the porch. But
right.
if they're in the street, it
Depending on the setting.
might not do
Right.
it. The problem is they were aware of the camera and didn't check it. So
Oh,
that
okay.
creates that
So
appearance.
now it overrid itself.
So it might not have been anything. It
Right.
could have been
Well,
nothing.
that's pathetic. I mean, you're dealing with a homicide. There should be no stops. They should be doing every single thing. Canvassing the neighborhood, talking to people who would have been in the vicinity of the incident. Everything. There's no limit to what they should be doing in a homicide.
There is body cam from.
It captures the taillight.
Yeah, there is a dash cam because Karen's parents live locally, but they live in a different jurisdiction, locally in the Massachusetts area. And they used that hunting officer, as a witness. And he didn't have a body cam, but his vehicle had a dash cam. And one of the defense exhibits was they showed, as best they could, what her taillight looked like
From
at the time of the contact versus then how it was presented.
Right. It's like, well, it wasn't that broken when she was on the side of the road. That's not good for the state. She finds the body. He's in the front yard, right? She calls the police. She's hysterical. The police get there. There's some video, dash camera footage that you don't really see any damage to the tail light.
Actually, have you heard the 911 call?
No, no. What was the
So
911 call?
there's some really interesting things in the 911 call for statement analysis. So the 911 call was made by Jennifer McCabe, who was a friend of Karen Reed's.
Okay,
And
was she there with her, or
yes. Well, but what's interesting is, like, say you were at my house and you were helping me do a project, okay? And I say, oh my God, my friend Lou, we were here, we were painting. He fell off the ladder and he's not conscious. He's not breathing. Help me. This is where I am. So 911 calls are to relay information as quickly as possible and to get help and direction. Jennifer McCabe is the sister-in-law of the homeowner, and she calls and doesn't say, oh my God, there's a friend of ours. He's a police officer. He's outside. We don't know what happened. He's been hurt or something. A very, very detached, neutral. There's a man outside in the snow. Like, she's really distancing herself from the person. And this is a person
is she calling 911 after Karen is there, or is
Yes.
this before Karen is there? Okay.
They were together.
They were together. So did they go in the same car to the?
Yes.
Okay, so she's calling 911 and Karen is, I imagine,
Freaking
with
out.
the body freaking out.
Yes.
Yeah. Okay.
So it's interesting. There's a guy. So this is somebody
who he was at that point, right?
They did know. She didn't mention the party that night. Take that for what you will. But the main thing to me was that this is a person she knows. And just by distancing herself from him in a way like that, I found very unusual. Why would you say a guy? A guy makes it sound like
I think
you're driving by on the highway and you're like, yeah, there's a guy on the sidewalk and he might be hurt. Not somebody that that's on the property of a person that's someone that has been MIA that you are looking for.
I mean, I'd give my non-conspiracy 2 cents on that. I mean, I've listened to a lot of 911 tapes. I've dealt with a lot of witnesses who, were going in to testify. In that type of situation, you'd be surprised what normally level-headed people might say or do on the 911 tape in the moment of panic. Maybe that's what happened here. Maybe it's not. I mean, I just offer it as potentially an explanation. But what I would also say is that if she has some sort of nefarious intent or knowledge about something that did happen, why did she go with Karen Reed to begin with and call 911 herself? So I hear you on that. That it was weird the way she phrased things. I don't know that I would.
Well, and she also
didn't do it that far.
She whispers a little bit like he's gone, he's gone.
Karen, well, right? Well, that's certainly suspicious. Yeah. Why? Would they?
Yes.
Keep searching? How long someone is before they find the body? She searched that.
Yes.
Suspicious. Yeah, that is. Did they call records? Like they're from this other woman's phone. They see that there's phone calls made to the homeowner like before they find the body. Yeah. Yeah, it's.
So
When did the trash truck go by?
That's also debated. I don't think he really has any stake in it. The state tried to really discredit him. He just seems like a regular guy.
Yeah.
Who was trying to be helpful. He misspoke in the first trial and they just really eviscerated him. He's just a normal guy who did not want to be on national television. I felt really bad for him.
Yeah. So not clear when he went by the house and would have noticed there was not a body.
He was very sure about the first time when the vehicle was parked there because of the route of the way that he goes. I think during the first trial, he said he knew it was 0530 because he saw police cars there, but that was actually incorrect. It was at 0630. So they really tried to rip him apart on, well, you were wrong about this time, so how are you so sure about the accuracy of your other time?
Yeah. What was the other time that he said? 2:30. So according to him, if you want to believe him, he says he goes by there at 2:30 and there's no body there. And then these text message info.
He says there's no body, but what he did remember specifically was that vehicle being in the street, of which the people who live there said that they don't park in the street and none of their vehicles were parked in the street.
So the police get there, she's hysterical. What causes her to say either I hit him or I hit him? Like, why is she saying that? Like, did someone say something to her first, or is she just in a state of hystericalness and saying those things?
She saw the broken tail light, and I think,
The
you
cracked
know,
tail. Well, theoretically, the cracked one,
the correct tail
right?
light. And
Which arguably she caused from bumping his vehicle on the way to the house to see the body
yes,
from
but then,
their version of events.
right where he was, then she was concerned that that she said that, and she said it just out loud, I think, in panic,
Sure,
not as an admission of
it
guilt.
definitely, you could argue both sides of that. I mean,
Mhm.
I don't find that to be any sort of definitive evidence. But is that what causes them to then target her as a suspect versus like, because my understanding, this is very limited. I don't know very much about the case, but from my understanding, they never interview anyone from the party or inside the house, right? Which that's absurd. That's just absurd. I mean, I can't imagine a world where this happens, in a regular setting, not law enforcement house, right? And they don't interview anyone. And I mean, that's insulting to me as a former prosecutor. Because a lot of times I would get cases, not so much homicides, because they're very. When I would get a homicide, by the time I got the file, it was very thoroughly investigated. They would pretty much look into everything that I would think of. But I would have a lot of cases I would get that weren't homicides, and I would say, all right, we need to, we didn't, they didn't, we need to go and talk to X, Y, and Z, or we need to go do this and this. If I got that homicide case and I'm going to trial with, not having had any of these people interviewed or talked to, but we got to talk to these people. We got to find out what happened at this party, because not doing it is just as bad as whatever they have to say. And here it is, not guilty verdict, right? I mean, if I'm on a jury and they don't talk to anyone in the house, what's the state's response? Oh, well, it's not important. Like, oh, we don't need to talk to anyone in the house. Like, what's the
So
big
there
deal?
was a
It's ridiculous.
pre-trial ruling that it was never even established that he went inside the house. So
Right.
they weren't even allowed to bring that up like as an alternative defense.
They know whether he went.
The court ruling was that it was never established that he was actually inside of the Albert home.
So
So they weren't.
the court instructed the jury that, ladies and gentlemen, there is no evidence in this case to establish that he entered the home of so and so.
There was a pretrial, or probably outside the jury presence, argument about it, and essentially it was determined that they were not allowed to present that he was at their home or inside their home for any type of party or anything, or that at any point he entered their home. That was just how
Well,
she
did
ruled.
those people testify, who, like, the people who were at the party inside the house?
No. So the state, there was a bar near where they live called the Waterfall. That's like a little bar and restaurant, and it had cameras. And in the first trial, they really focused a lot on who was present at the waterfall, where they sat, how they're interrelated. The first attorney for the state was a guy named Lyons. He was very, very dry, and he would just run through how all these people were interconnected. Like, were you born in Canton? Have you been raised in Canton? Do your parents live in Canton? What high school do your children go to? Do they play sports? Do they play sports with the family of these other people? Like, it went nowhere, and he did it with every single witness. I didn't understand the point of it. It was like, yeah, they live in a small town, they all know each other, and they're at a bar. Great. But he did that with every single person. So they focused a lot on who was sitting where at the waterfall, and
Before the party?
this is in a public bar before they're at the
So are all the
Albert's house.
people who are at the party at the water at that bar, and then they go back to the house for the party, or is the party going on and there's some people at the bar who then go to the party?
It's debatable because not everybody was interviewed. So,
Right.
you
Well,
know,
I mean, it sounds like, and then was this investigated then by the same department who the person that lives in this house is a part of? Like, who
no,
investigated the case? Was it investigated by the prosecutor's office, the county?
no. So here's another investigative problem. So in the state of Massachusetts, any municipality, with the exception of the Boston Police, the city of Boston investigates their own homicides. Any other municipality outside of Boston, the homicide is investigated by the state police.
Okay.
So in the beginning, when the call first started and the Canton police were dealing with it, they
Notify the state police.
Well, they did, but the victim wasn't deceased. So they said, well, you don't really know what you have. He's not deceased, so we're not taking jurisdiction. So it was
So Canton continued to investigate.
Canton, who's a smaller agency, was trying to, document and preserve evidence in some pretty ridiculous ways, but also they don't normally do
And
that.
just to clarify, the homeowner of the house where the body is found in front of and the victim himself are both members of the Canton Police Department.
Boston
Police Department. Okay.
Boston Police. So they live in a suburb. They live in a suburb of Boston.
I understand. So Canton is investigating this, and the people involved are members of the Boston Police Department.
Yeah, that's correct.
How long before the state police took the case over?
Hours. Yeah, and a lot of the scene. Well, one, I mean, I've never been a cop in the snow. I've worked cases in torrential rain, which sucks. But I understand the weather is miserable. It's super cold. It's snowing. The scene is changing. They were trying to preserve things as best they could, but they just did some things that don't reek of a professional, crime scene. So they wanted to collect some blood samples that were in the snow, and they had no way to collect them. So they asked a guy across the street who happened to be a policeman himself if he could have some
How did they not
plastic.
have any way to collect blood samples? Like
No,
they
they
didn't
didn't,
have
because they don't
a buccal swab.
they used like a plastic disposable Solo cup.
The normal way to do it is you have a moist buccal swab. It's a kit.
I
A
know.
vial and it's like a Q-tip. It looks like basically, and it gets wet with sterile water, and you you smear it on the stain to get the stain onto the Q-tip, and you put it in there, and you seal the vial. Every officer normally has it in the back of their.
So for an agency that doesn't investigate, it's like a township.
Yeah, I get it. They're smaller. They probably the first time they had a homicide in God knows how long. But
Right. So I don't know anything really about their city, their level of violent crime or if they're exposed to that. But in their state, when a murder does occur, it's investigated by the state police. So
so they're not really ready to jump in a case like that. But
another thing that they did, you'll love this. So it gets better. So they wanted to clear off some of the snow so they could look for potential evidence, and somebody had the bright idea to actually use like a snowblower. I'm sorry, a leaf blower, and use it to, clear.
I will say though, like I've never had a situation of like there's snow covering this entire area. There could be evidence here. Like, how do we get to it? Like the whole front lawn is a crime scene. I mean, there could be other things under the snow on the front lawn that's of value. Blowing up the snowblower is probably a bad idea, but I don't know what the proper procedure would be.
Well, I mean, I would argue that if there's something, say there wasn't a knife in this case, but say there was. So there's a knife there. If you secure the scene and hold the scene, eventually that snow is going to melt, and then you would be able to photograph, measure.
How long would that be? I mean, like, what if the snow doesn't melt for like? I mean, it's really cold.
It is. It's like I said, I've never been a cop in a snowy situation. But
I've never had a case like that. So yeah, I mean, like, I legitimately wonder, like, how do you? I don't think snowblowers.
But I think
how do you secure that?
In absence of in absence of doing something at a crime scene where there's really no exigency to do anything, sometimes you have to hold the scene and figure out what's the best way to move forward.
They could have caution taped around. Don't step over here. We're just gonna leave this. We're gonna
Yeah,
figure out how to
we're gonna
handle
put
this.
the tape up. We're gonna post
Yeah.
a few uniform guys on it, and we're gonna figure out how we're gonna proceed. That would be best.
So I want to just recap the state's case here. So Karen Reed and the victim, they go to this bar. They leave the bar. They go to the party. Karen Reed drops him off. Maybe he's supposed to text her and she's going to come later. Maybe not. But she goes home. And then there's text messages sent by her to him, like, hey, what are you doing? Where are you? Calling him.
Yeah.
That morning, she gets in touch with this other individual who's the sister-in-law of the homeowner where he's found in front of the house. She then drives back to the house, finds him on the ground, dead. He doesn't have any snow on him. He doesn't have any of those issues with his stomach that would be indicative of him having hypothermia and dying, in the cold. So it appears that from a medical standpoint, he was already dead in snow. She maybe sees this crack on her taillight and thinks like, oh, did I hit him? And, the state's theory is that she's confessing. The defense's theory is that she's hysterical and is just, saying this in a moment of panic. Person that calls 911 has phone calls with the homeowner where he's found in front of the house of multiple calls in the early morning hours, 1:30, 2:30. The people in the house are not interviewed. They're not witnesses. I imagine the police then target her because of the statements she's made in the front lawn and the crack in the taillight, which is then not well documented because they should have taken pictures in the scene, but now it's a question of, well, how much damage was there? Did they damage it, on the way back to the police department? So there's a lot of question of like how much damage is on this taillight. He has a fractured skull, which not sure how you get a fractured skull from a car backing into you and you land on a lawn. Was he laying face down, face up? Like what was the orientation of his body?
Face up. The state hired a company that is like a biomechanical engineering reconstruction company called Aperture. And the defense hired a company that's called ARCA. I'm not sure if ARCA is just the name or if it's an acronym for something, but ARCA, their expert, was it Dr. Wolf? The guy that I'm thinking of, he was an incredible witness, very, very professional, very well trained, very articulate. He did a really, really amazing job testifying. And unfortunately, Lou, this, is that your attitude sometimes in court can affect how people perceive your testimony. And I felt that the Aperture guy kind of seemed like a know-it-all jerk. That doesn't mean that he's not smart or not good at his job or whatever, but I think whenever you appear that kind of snarky, argumentative in front of the jury, I think no matter how good the information that you have is, it like damages your credibility.
Sure. Just to recap there. So these two battling experts were talking about the reconstruction of the impact of the car. So obviously the defense expert, I imagine, was saying like, well, yeah, these injuries are not indicative of what they're alleging happened in this.
So the defense expert says, I can't prove that a collision occurred at all.
Right.
Biomechanically, and they had the x-rays of his arms. He had information about like pounds of pressure to do damage
to the skull. It's not easy to fracture your skull. Like you have to, I mean, I I had a case where a guy got beat to death with a baseball bat, and you saw fractures in the skull from that, but it didn't crack. There was crack lines, but it didn't actually like break the skull.
Right. It was a fracture, not a. I understand what you mean.
Right. Yeah. There was just just cracks from the bat, a bat, multiple times, and you knew it was multiple times because of the number of like pattern abrasions on the back of his head.
Off and
and like just you could see the spots on the back of his head where he was being hit. So to the idea. I mean, I'm not an expert, but the idea that this guy got hit so hard by this taillight that it cracked his skull, and then the taillight is just slightly cracked, and there's no other damage.
Well, and also
Definitely, it
there's
definitely raised his eyebrows.
and the state witness did some testing and video recorded it and had some different like exemplars. So they had a vehicle similar, same make, model, size that reportedly Karen Reed was driving, and then they did some live testing with a person and like had blue grease paint on the vehicle to show like where the if you were standing, but they don't know exactly where he was standing, so it's kind of all hypothetical. It wasn't great. I think that he definitely didn't portray it well, and also, scientific method. I have to have very, very strict controls. Also, that experiment can be duplicated by somebody else and achieve the same.
Was that challenged like before? I mean, I imagine the defense challenged the admissibility of that expert report. Like, did they have an actual
Yeah,
hearing
so
on the
he
scientific
testified.
reliability?
Yeah, he testified. He completed like a prepared written report, and then they also had like video exemplars, that they would
Right.
show, and then
I would say that like most experts are going to say like, yeah, like I can't say with absolute certainty that this happened, but in a reasonable degree of professional certainty, I believe.
yeah, they had a very specific term.
Fancy term, fancy, it's different in other in depending on the jurisdiction, but
Yeah.
yeah, okay. So to get back to the recap, essentially though, we left off with I had asked like what was the orientation of body and how do they know, like how could he? I mean, imagine this theory had to be that he was crouched down, right, when the car
No,
backed up.
so they're saying that he was standing, and then the injuries on his right arm were because he was holding a drinking glass, like a shorty, like a nice
Okay.
bar glass, like a thick
Okay.
glass.
A glass that wasn't found at the crime scene, right?
Broken pieces were found of it.
Okay.
After they released the scene, they kept driving by the home and doing additional like
Yeah.
searching, and
Like, oh look, we found another piece of car. There it
yes,
is.
yeah,
Did it fit into the like? Could they be like, here's this piece and this is where it goes in the vehicle?
there's a specific name for that that reconstruction. I can't think of what it's called, but no, they did not like where they piece everything back together
Yeah,
and
you're
say
like, all
like
right, well, like
the
here's the
cumulative
car.
number of pieces that we have make up the pattern matching.
Well, the problem with that is that at that point they probably already released her car back to her because they're not going to. Or did they keep the car as part of that? I mean, or usually cars, you get a warrant, you take it
They
in, you
kept
take
it.
pictures of it. Did they keep it? Okay, so they
They
had
did.
the car, so they could have theoretically done that or tried. I mean, not trying. I always like said to people like prosecutors, when you don't when you may try to look into something like that and then it doesn't work out and it hurts your case, but not trying is, in my opinion, when I was like, in my opinion, is almost worse than trying and it doesn't fit together. You know what I mean? So like, yeah, to not try that, it's kind of like the state of Massachusetts, like in a homicide, couldn't find someone to try to put pieces back together.
They tried in the first trial. They ignored it in the second trial. But to me, then it
They
also
tried.
becomes
They had someone try to do it, and then it didn't
they
work.
did. They had a young lady from like a criminalist try to explain it, and putting the pieces back together, trying to like jigsaw it back together.
Yeah.
But to me, also, if you perform experiments like that or try to do recreations or show things like
We're
that,
talking about the accident or putting the taillight back together.
anything. Now that's a Brady issue because that's, to me, that's the same as if you show a photo pack to a witness and they don't make an identification. That's exculpatory. And just because I don't like it because it doesn't fit what I want.
Did they not provide that to the defense when the lady couldn't put it back together?
But what I'm saying is, in terms of like their experiments, like what's their process? How was it documented? Was it video recorded? Was it like any of those processes. And the most important thing is that it can be replicated by a third party person, or that somebody else would come and have the same reasonable result that you have. That's how I feel about it. That's probably.
Well, did they not document their process, like for the defense expert to see how they, reach those results? Was that an issue?
It was an issue for me, but I mean, I didn't like how it was presented. I'm probably a
Yeah,
little.
I mean, I agree. Like if this was a New Jersey case, there would have been, especially if they were doing something that hadn't been done before or found to be. I mean, accident reconstruction is not like something new, but if they were doing anything in that, I mean, there's a few things. Like, first of all, there's whether or not the expert report is scientifically sound, and every state has a different standard for that.
Is New Jersey a Fry or a Daubert state? It's procedural. It's basically a series of hearings to qualify if a method is science. Yeah. I the term they use often is like generally accepted in the scientific or the forensic community. Like, at one point fingerprints were new, so are my fingerprints the same as your fingerprints? Or maybe because we're the same background, maybe because we're both Caucasian, are fingerprints exclusive to people? Um, do people's fingerprints copy? Are they generational? So there's all these things. So at one time that had to be proven as a standard. Daubert was in 93, and it's a scientific safeguard to really show that whatever method that you're presenting is scientifically sound, and that and a benchmark, and that it can be repeated by a neutral person, and the judge in the case usually acts as like the gatekeeper of, is this information valid, that it's not like phrenology, where we're basing you know criminal characteristics based on the shape of your skull or something ridiculous like that. So that's all that it is, and each state has a different one.
In any case with scientific evidence, you have the initial threshold of, is this a reliable scientific uh, result or test or whatever it is, and there's Daubert and there's Fry, and every state is a little different in how they handle the standard of whether or not that evidence comes in or not. But essentially, if something has already been found by a court to be scientifically reliable and it's been affirmed on appeal, that essentially makes the future use of that tool automatically assumed to be reliable. And the next question becomes, is the opinion or the scientific evidence in that specific case, was it done properly? Is it a net opinion, which means it doesn't rely upon enough sources or material or things to be used in the case here? You know, for an accident reconstruction, it would be largely. I have never had a case of an accident reconstruction, but I imagine that it's going to be based upon the different testing used, to recreate the accident, right? So, like, is it the same car that they're using? And, like, are they using things that match what was actually, like, what actually was involved in the case, like the type of car, the weight of the victim, like, those types of things. That's obviously going to be very, very pertinent. And then I don't know the specifics of that opinion, but I would imagine that the defense, in a case like that, you're going to challenge that piece of evidence in any way you can. And if it, from a scientific threshold standard, though, if accident reconstruction was already something that was found scientifically reliable, as long as that test was within the realm of that type of scientific test, that's not going to really be litigated before the trial because it's already been decided that that type of thing is admissible. So it would have been more of specifically, like, did they do, is that report done in an appropriate way, that so that it's relying upon the things that the upper courts have said, like as long as an accident reconstruction like is relying upon X, Y, and Z, we find it to be scientifically reliable. That would be the threshold question there. And then the next one is
So like the defense did multiple tests with a dummy,
right.
whereas the state witness did tests, but the expert was actually the subject in the video. So
Yeah, it's weird.
to me, I didn't like that at all, because you want your results to appear
I mean,
as
did he like was he the same build, weight, and as the victim, or
that's what he stated,
yeah,
but
yeah.
yeah, and
It's
if
not
you're doing
it's not like there's nothing per se wrong with that, I would say, but like it doesn't look good. It's like you're
yes,
doing a test. You're the scientist doing the test,
yes.
right? Like you should be one removed for you shouldn't be a subject in the test. Like it's just not it doesn't look professional. Yeah. I know yeah, I don't think that that was a smart thing for them to do. Just strategically not a good thing for them to do. We went over a lot of the facts and the evidence in the case. And is there anything that we didn't cover that you would want to talk about or mention?
Yes, the dog bite
Yeah, we
testimony.
didn't go over that too much. Tell me about the dog.
No, so to me, what's so interesting is the when they his clothing on his right arm. There's a cut where I don't know if it was made by medical intervention or so they could do studying and photographing of his clothing, but there's a series of circular tears in the fabric that closely align with the injuries on his arm. And what the ARCA expert said was essentially there's nothing on the vehicle that would cause that type of pattern
Right, Pat.
injury. And then they had a very, very bright lady on who had been a doctor, a police officer, a pathologist. She's pretty much done everything. And she was an ER doctor at one point, and she was trying to testify about pattern recognition for dog bites. Um, the state and the judge were just trying to shut her down at every turn.
Right.
It was very weird to me because
Where did the idea that there was a dog bite come from? Like, was there some other piece of evidence that brought up a dog bite other than the injury itself? The defense's theory is what? That there was some sort of altercation inside the house. The dog bit him, and the other homeowner or someone there hit him over the head with something. And
they they weren't allowed to present any of that, but I'd imagine that they would have went that way.
yeah,
What their primary defense was, Karen Reed did not hit him with the car.
yeah, I got you. All right, guys, I have to run. Chris, thank you for coming on. Appreciate it.
Oh, thank you.
I think we had a pretty good conversation, guys. I'll see you later.
I found most interesting is just, yes, there's all kinds of crazy hexagonal conspiracy, what if this and this person's connected to that and these people know each other and everything. But let's really just boil it down to the simplest things is what would cause injury on the decedent's arm in a manner that it was found? And the answer is not a car.
Pretty
You know,
much.
so if the state's theory is that he was hit by this car and then that caused these injuries and then it caused him to fall, and they kept focusing on the ground. They called some NOAA guy, like a National Weather Service guy, to talk about the cold and percentage of amount per hour of snowfall and stuff, which I thought that was kind of interesting, but there was no measurements of how much snow was on him or how much snow was on the scene. Because you might have been able to like extrapolate backwards if you had, X amount of inches of snowfall per hour, but they didn't have that data. So yeah, it snowed. We know. It really, it was a long explanation of a guy who had been in the weather service for many, many years to say it's Massachusetts. It's cold. It snowed.
Yeah, I don't know why. I got to be honest. Some of the presentation made by the prosecution really puzzled me. Like, would that how do they expect, like, how is that going to resonate with a jury, or even, I mean, my God, I wonder if they saw what their accident reconstructionist had in mind before they brought it up in court. Because if I'd have paid $300,000 for that, I'd have been like, you got to be kidding me, right?
It's all it's all discoverable. So, they review it. It has to be provided to the defense ahead of time. But of course, you're going to want to look at it and prep and review it and review testimony and your line of questioning and what you're trying to prove. I just think that expert had never been challenged in a way in a courtroom where he was challenged that way, where he had his credential or his theory critiqued in that way. I don't think he was prepared to defend his methods.
Oh, we didn't even get to his coworker.
The Southern guy, he kind of had a Southern accent.
Yeah, that dude who worked for the same company, and they had to pull him off the website and change his LinkedIn overnight because
So
he'd been working for the same degree for 17 years.
yeah, he's almost there. He's almost got it. But yeah, because like he claimed he had like a bachelor's of something or a master's of something and actually really didn't possess that degree. In all cases, everything is fair game about you. If you're called as a witness for the state or the defense, and I really don't think people sometimes think, about things that they've said or done publicly before, or what is consumable in social media or things like that, like is going to come back on them,
Oh,
that that guy wasn't ready for that for sure. Tom, I lost your audio and now I lost your picture.
Sorry, my phone was ringing. It took my earbuds away from my computer.
Yeah. So, for your notes for later, so they found her only guilty of the
Operating.
yeah,
Yeah.
operating, which I think their state calls OUI. She got 1 year probation and then 24-day or 24 course, probably 24-hour driving course. I was just looking online. But, so she'll have to pay some fines, maybe have like an interlock device on her vehicle, maybe have like a license suspension. But I think that way, like you said, it's a strategy where it allows them to find her
Pressure
guilty
release.
of something and say, she didn't walk away scot-free, but, she was able to defend herself against the most serious charges, because her operating the vehicle isn't in dispute. It's, did she hit anybody with it? That was the question. Yes.
Because they only drew breath in the morning. So they had no evidence. I mean, they had circumstantial evidence, I guess, and maybe a picture of her drinking, but nobody drew blood. They can't prove I don't know if that holds up in court, but
And I mean, the thing that I'm sure she and her team are grateful for is the not guilty verdict allows, or doesn't allow the state to ever bring this forward again. But there is something I wanted to tell you about that, to include if you weren't aware of it. Do you remember one day during the trial they called it a little earlier than usual?
Aunt Bev was Person of the Year in the Norfolk Bar Association community, right?
Yes. Do you know who was a platinum triple sponsor of that event?
The expert witnesses for the prosecution.
Yes. Aperture. So during a trial in which she is presiding, a state witness is I don't know how much of a contribution that is. It sounds high for a dinner like that, but it doesn't matter if it was $5 and a Chick-fil-A sandwich. It's the appearance of impropriety. And she should have absolutely said, I'm grateful that you've nominated me for this, but I'm in the middle of a trial. This involves these people. I can't attend or accept any type of award or anything at this time because it would give the appearance of impropriety. And she went and she accepted the award. The appearance is everything, because it doesn't really matter if it's true or not. It matters what it looks like. And if it looks like you're at a paid dinner function getting an award for a prosecution witness during a trial that you're proceeding over, it just looks bad. And there's no way that you can spin it that it looks good. And like I said, she could have very gracefully, said, I appreciate it, but I can't accept it at this time. And I wouldn't even attend, because declining to attend, it takes all the wind out of the sails. I think, I mean, ultimately it doesn't matter now because she was found guilty, but I think there was, or found not guilty, but I think there's so many issues like that, that if at an appellate level, there would have been a million things to show either conflict of interest or appearance of impropriety or favoritism, that being one of them, and a lot on her motions. In Florida, we call it a JOA, a judgment of acquittal, where a defense attorney will say the prosecution has not met the statutory requirements for this offense, whatever it is, and lay out, that they haven't met the grounds and the statutory burden for that offense, and ask for a dismissal for a release mid-trial. It usually happens before trial, but it can happen during the trial too. I don't know the term in Massachusetts, but they asked for that several times. Jackson and I think Yannetti, Yannetti did the one particular argument that I'm thinking of. It probably was about 10 minutes. Very, very well crafted. And, she, without hesitation, without even acting like she considered it, immediate thumbs down. It's like, give it a beat. At least, if pretend you're thinking about it, let him give his argument, and then move to a different issue, and then come back to it in 20 minutes, take a recess, something. But I mean, he presented a very, very well crafted oral argument about how the state had failed to meet its burden, and just immediately didn't.
That's been the observation of a number of commentators from the legal sphere, is not just the number of sustained, but the amount of thought that goes into ruling on these motions has been disproportionate, in that she will put a lot of thought into and say, I'll let you know tomorrow.
Sure. And sometimes judges issue a ruling, especially if it's a very, very large ruling that has heavy implications for the case. Sometimes they issue it in writing, and they'll cite previous case law or cases with similar fact patterns, and they'll have their JA help them craft it and properly cite it. Not that every motion requires a written response, but there's one more thing I want you to look at that I think would be really, really interesting. I don't have time to discuss, but I know you'll be able to find some video of it and maybe splice it in there. Did you see any of the motions between, at one point, I believe it was Mr. Brennan and Judge Cannoni, where at one point, like, his back was to the camera, he was questioning a witness, and he's like nodding in the negative to the judge, and then the judge says something. Did you notice that?
There's a couple clips I've seen that allude to Cannone communicating with the prosecution. I mean, there's one where they've got her doing like hand signals to the face kind of thing. Like,
Yes.
it gotta be in
My wife
totality, though.
like they were telling him to steal third, like, I mean, it was ridiculous. And now, could it have been innocent? Maybe, but
But in totality, with the tone of the proceedings,
it's the timing, and that whatever, I can't remember exactly what was occurring at that moment, but I knew it wasn't going the way that they wanted it to. And then she cut the testimony. I think that particular one that I'm thinking of describing, with his back to the camera and the judge is kind of like on a diagonal view to him, they ended for the day. So it's like, it was going a way that they didn't hope it would go or want it to go, and then okay, all right, we're calling it for the day. So I just things like that. And I know I'm not the only person who picked up on that.
Well,
Those
that's why this case has so much attention, I think, is nobody who's watched it for a significant amount of time. I mean, I feel like it just looks like crooked. Like I said, in totality, her touching her nose when he's stepping in a pile of shit of his own making, maybe it means nothing. But man, when you've watched her for, pretrial hearings, when you watch her, you immediately think she's signaling the prosecution. That's a bad place for the public perception to be. And the only reason this case has as many eyes on it right now as it does is because people like me looked at it, couldn't look away because it looks like a car accident every time she's stonewalling or giving the appearance of stonewalling the defense.
I will say, I wasn't familiar with Mr. Brennan before this case, but he is fiercely intelligent and just an absolute pit bull. I would not want to be on the witness stand and have him tearing it into me, because I mean he just has a rhythm and a cadence and a presence and is very,
Wait,
very
Jackson or Brennan?
no, Brennan, the state. Jackson's good too. Unetti's good too, but Brennan, he's actually normally a criminal defense attorney. He was appointed as a special prosecutor for this, but how he went at some of those witnesses, I would definitely not want him coming after me on the witness stand. I just wanted to get that in there. I feel that he would be a formidable opponent in a courtroom.
I can't wait to see if the FBI's doing anything, because there's affidavits that came out of the Turtle Boy case that the previous prosecutor, Lally, was in cahoots with the lead juror on the first case, was paying people in the community. I think indictments are going to come down on the back end of this on topics that people never saw coming. But that's an affidavit from a member of that community that is associated with the Turtle Boy case that relates back to the Karen Reed investigation in ways that makes it look like if somebody does some investigating on these people, this could be like a movie. Like, I mean, we're talking state, local, and federal law enforcement entities in a murder cover-up potentially, and they didn't do anything to make it look less likely the way they handled the trial.
It's all about the appearance of impropriety and, have to do things in a way that are procedurally correct and a way that things make sense. And I think even somebody who isn't in law enforcement or criminal justice or in the court system just saw things that just didn't sit right with them, where they said, that seemed weird, like just intuitively, some snap decisions that were made that just didn't seem correct. And then I think, obviously it was a huge media firestorm, but on to the next now. I've also wondered too if Karen Reed has I'm sure this whole process has financially probably crippled her and her family, if she has any interest in pursuing some type of civil recourse if there's an avenue for her for that. The thing that I would end with is, with all the shenanigans with the prosecution and the defense and the different lawyering and the strategies of all that, which is so interesting. John O'Keefe is still dead, and something happened to him, and we don't know what. And I think something criminal happened to him, and we don't know who or why that occurred, and that needs to be properly investigated so there can be some kind of justice for him so that those questions are answered. But I think it would have to be conducted by an outside authority, because I think everybody in that area is too intermingled and too close to it, where you would have to have people from outside the area that have no connection to that and just basically start it from scratch and redo everything. Unfortunately, I don't think that is going to happen, but I think that would be the only way to almost investigate it like an unsolved cold case, and then just go back and redo everything that you possibly can and try to get some kind of definitive answer. But unfortunately, I don't think that'll occur.
or if the evidence exists to execute that in a way that would allow you to do anything definitive. I mean, it's so after the fact, and so many phones have been destroyed, that kind of thing. It's like, you might be really, really handicapped by what's available. That's all I'm saying.
Well, all cold cases are like that. There's things that were done improperly, things that you wish were done that weren't done, or people that you wish you could talk to again that are deceased or uncooperative now or whatever. To me, that would be really interesting, is trying to figure out exactly what occurred and if anyone is truly criminally responsible for what happened to him. Now the big part's over, but for the O'Keefe family, they still lost their loved one, and you never get over that.
Oh, I'm
And
sure.
I just wanted to make sure that, in this, we talked and joked a lot about, different funny things and funny moments in court, and different unusual procedural things that I saw and that, many different people noticed. At the end of the day, this is a trial. I mean, he happens to be a policeman, but it doesn't matter if he is or not. He's still a person, and he lost his life. We don't know why.
I think that's why so many people seem to really hate these people. So many people are really rooting for amateur and probably professional investigators who were just as interested today and tomorrow as we were yesterday. Like, I do think eyeballs are going to stay on these people as suspects. You would think maybe that'll drive something, actually.
Ultimately, unfortunately, all these cases are about the loss of someone's life, which is nothing that, no amount of guilty or not guilty verdicts or anything, that person's gone forever. And there's nothing that, unfortunately, any of us can do about it.
All right, good enough, man.
If your firm is looking to podcast a little or a lot, check out legalpodcasting.com. Or if you're on NewJerseyCriminalPodcast.com, you can contact us right here through the contact form, email submission, or leave a voice message.